Hey, future real estate pros. I'm Cameron, and today we're kicking off our journey through the North Carolina real estate exam with Chapter 1, Brokerage Practice in North Carolina. If you're planning to take the state exam, you'll definitely want to master this chapter. It could show up in around 12 questions. So let's break it down into something real and practical. Let's start with what's called regulated in real estate here in North Carolina. The North Carolina Real Estate Commission, or NCREC, is the main authority that oversees what we can and can't do as brokers. Land use controls. In North Carolina, zoning and land use rules are serious business. The state government gives counties and cities the power to decide how land can be used, whether it's for houses, businesses, or farms. Here's the deal. If a property is restricted from accessing a public road, that's a material fact. We have to disclose that. We also need to mention if there are HOA rules or restrictions, or if big changes like a new highway are planned near the property. And no, we're not expected to be zoning experts, but we are expected to spot red flags and refer clients to attorneys when needed. Interstate land sales. This one's more federal, called the Interstate Land Sales Full Disclosure Act. Basically, if a developer is selling land across state lines, especially big subdivisions, they've got to disclose a ton of information so buyers aren't misled. If there are 100 plus lots involved, the developer needs to register with the Consumer Financial Protection Bureau. If you're working with land sales, make sure you understand when this law kicks in. But here's a shortcut. Fewer than 100 lots, 5 acres or more, or sales within North Carolina, these usually don't apply. Environmental issues. If you know something could be hazardous, like underground storage tanks leaking oil, that's a material fact too. Always disclose it. Encourage your buyers to hire professionals for inspections, especially when there's a known risk like a buried fuel tank. Next up, handling documents like offers and contracts. Once you get a signed offer in your inbox, you've got 3 days to deliver it to the right people. Even if the property's already under contract, you still have to present it. You also need to share all offers at the same time, if there are multiple, give everyone copies of any signed agreements, double check the settlement statement before closing. It's your job to make sure it's accurate. Advertising. If you're promoting a listing, make sure it's truthful and not misleading. This means no blind ads, get permission before advertising someone's property, and be crystal clear. Don't exaggerate or hide important details. Record retention. You have to keep records, whether paper or digital, for 3 years. Contracts, emails, notes, keep everything organized because the Real Estate Commission can ask for it anytime. Handling trust funds. This is huge on the exam and in real life. Trust money is money you're holding for someone else. Think earnest money, rent, deposits. Rules to remember. Put it in a separate trust account, not your personal or business account. Deposit it within 3 banking days, and don't mix it with your own money, except up to $1,000 for bank fees. If you're holding money in an interest-bearing account, everyone involved has to agree in writing. And even if someone else is handling the day-to-day, the broker in charge is ultimately responsible for making sure the money is handled correctly. Let's move to what you're not allowed to do. Misrepresentation and omission. You can't lie or hide the truth. If you know something that could change someone's mind about buying, selling, or renting, you have to say it. That includes property problems like synthetic stucco or past meth labs, leaky pipes, even if they've been replaced, even stuff like future zoning changes or flood risks. Forget buyer beware, you're the one responsible for disclosure. Discrimination, this one should go without saying, but discrimination is illegal. You can't treat clients differently based on race, gender, religion, disability, or any other protected category. Practice of law. You can fill in pre-printed forms, but don't get creative. Writing your own legal clauses? That's a job for an attorney. Stick to the script. Commission problems. Brokers only get paid by their broker in charge. No side deals with other agents or clients. And out-of-state brokers, you can work with them, but only under specific rules. Disclosing offers. You can't go around telling other buyers about someone else's offer unless the seller gives you written permission. No shopping offers around to get a better deal. Finally, don't forget to review the settlement statement before closing. Even if you didn't prepare it, you have to make sure it matches the contract. Mistakes can lead to disciplinary action. So that's your quick and clear overview of Chapter 1, Brokerage Practice in North Carolina. This stuff might sound technical, but once you get used to it, it just becomes part of how we protect our clients and do business the right way. If you found this helpful, give it a like, subscribe for more chapters, and check out the Spanish version if that's your jam. Until next time, study smart, and I'll see you at the closing table.